Welcome to Brief Encounters. My name's Ann Wilcox. I'm a steering committee member for the DC Affairs community of the DC Bar Communities, and I'd like to thank the bar staff for arranging this conversation. We're very pleased to be speaking with Mr. Jinwoo Park, Esquire, who's the director of DC's Criminal Code Reform Commission for this conversation. Jinwoo Park is the executive director of DC's Criminal Code Reform Commission and joined the staff of the commission when it was formed in 2016. He was named executive director in 2022. And for context for this conversation, I want to refer our listeners to the CCRC website for background, as well as the DC Council Committee on the Judiciary and Public Safety for committee reports, hearings, and other information on the legislation. The DC's Criminal Code Reform Commission was established by the Council in 2016 as an independent agency to provide recommendations to the Council and Mayor for revising DC's criminal statutes. The Commission worked for about 5 years developing recommendations for the revised criminal code, conducting an exhaustive study of current district criminal law and practice, reviewing model legislation and best practices in other jurisdictions, researching relevant social science literature, and analyzing the district's charging and sentencing data. The reason for the review, as Mr. Park will elaborate, was the district's current criminal code has not undergone a comprehensive review for over 100 years since it was created by Congress in 1901. It still uses the 19th century structure, relying heavily on court opinions to develop the elements of crimes. But when the model penal code was promulgated by the American Law Institute in 1962, most states comprehensively restructured their statutes. The district was one of the few jurisdictions that didn't, probably part of our unique status as being a federal district under Article 1 of the Constitution. Piecemeal revisions by the City Council were made under Home Rule, but have not addressed structural problems with the DC Code and the need for clarity and consistency throughout. The Commission staff was aided by an advisory group, which included representatives from the U.S. Attorney's Office, the Attorney General, the executive branch, as well as nationally recognized experts in criminal law on both the prosecutorial and defense sides. Turning to you, Mr. Park, with that background, can you tell us what the original law in 2021 contained, what were some of the themes, and what you were hoping to accomplish?
Thank you, and thanks for having me here today. Yeah, well, as you mentioned, our code has not been comprehensively revised in over 120 years now at this point. And most states did effectively what we were trying to do decades ago. And so the problem with the code, though, isn't just that it's antiquated or hasn't been revised in a while. It just really failed to perform the two basic functions in a code ought to. And that is, one, just clearly defining the law so that it's very clear to practitioners and laypersons, what kind of conduct can actually warrant you being arrested and sent to prison. And then second, within the context of what's actually criminalized, it doesn't really always provide penalties that are proportionate so that the punishments don't always fit the crime. And just to give some examples of this. So there are numerous offenses that are completely or just partially undefined. So, for example, our assault and manslaughter statutes say literally nothing about what those offenses entail. We don't have any generally defined common defenses, such as self-defense or duress. So it leaves the sometimes very basic legal and policy questions completely unresolved, which creates a huge amount of uncertainty for defendants, for practitioners, and really leaves it to our district courts to try to do their best to fill in the gaps. And we also have, again, disproportionate penalties. And this is a result of just penalties being made in a kind of haphazard fashion over the years, and also offenses that are just written too broadly. So to give one example, our robbery offense has no penalty gradations. And so it's very broad. It includes everything from a robbery in which someone suffers really serious injuries and has to be hospitalized, but also includes completely non-violent, non-threatening pickpocketing. And all that conduct, which differs immensely in terms of its severity, is all treated as the same offense, subject to the same exact range of penalties. This is kind of like the base fundamental flaws with our current code, which again, other states have mostly addressed decades ago, and that we were trying to address and had addressed through the Revised Criminal Code Act, had it not been for federal government interference.
Right. I know as a practitioner in the DC Superior Court on the criminal side, we were always thumbing through the Red Book, which had this huge leaflet book of jury instructions to get the elements of the crime, and things were not defined. You also had to eliminate antiquated crimes that no longer existed, like, wagon wheels and those sorts of things, right?
That's right. There's, again, because the code is so old, there's references to steamboats and beasts of burden and playing games of shindy in the streets, and those things did need to be cleared out, but they're not really the most serious fundamental problems with the code because they're generally not really prosecuted anymore. These basic questions of lack of clarity, disproportionality, these are problems that really do arise routinely and they will continue to arise if they're not addressed through comprehensive code reform.
Right. One thing about the sentencing, there was a lot of concern about sentencing revisions, but a lot of that was to reflect actual sentences being handed down by judges in this current period. Is that correct?
Yeah, that's right. We had 10 years worth of data from DC Superior Court. So every adult case that went through DC Superior Court. So we could actually look to see not just what, say, the maximum penalty for a current crime is on the books, but then see what's the range of sentences that are really being handed out by district judges. And as a design issue, what we tried to do is in virtually every case, whatever the new maximum sentence that we were recommending for a given offense, it was in almost every case as high and almost certainly significantly higher than not just the average sentence, but even the longest sentences that we saw over a full decade. So one glaring example is there was a lot of press about the supposed reductions in carjacking penalties. We looked at that decade's worth of data. The max sentence that we had recommended was about 50% higher than even the longest sentences that we saw over a full decade. So even the stiffest sentences that judges were handing out, they would have been fully authorized under the RCCA to hand out similar or even much stiffer sentences. And again, this is a deliberate design choice when we set new maximum penalties so these new maxes more closely aligned with actual district practice.
Right.
So some of the technical reductions on paper really would not have had an effect or a very limited effect on actual sentences that would have been handed out.
Right, right. And it would also be more consistent with sentences in other states like, Kentucky or Ohio or some of these other jurisdictions where the members of Congress were looking at our code.
That's right. The max penalties were also consistent, not just with DC district practice, but were also broadly consistent with national norms as well.
Mhm. One other area that came up a lot was the issue about increasing eligibility for jury trials. I'm familiar with working under the Misdemeanor Streamlining Act, which said that any crime with 180 days or less was not eligible for a jury trial. The proposal sought to expand that, and that created some controversy because we don't have control over confirming our judges. We may simply not have enough judges to hold all those jury trials. Can you expand on that a little bit?
Yeah, and so to be clear, that those listening don't know that. So the Supreme Court has said that the constitutional floor for when a person is guaranteed a jury trial, among other things, is if it's a petty offense, you do not have a right, and that offenses are presumed to be petty if they're punishable by under 6 months. So currently, our jury trial rights are set at the absolute constitutional floor. The vast majority of states, about 40 odd states, either guarantee a jury trial anytime a person's facing a charge with any period of incarceration possible. Or if they have a bench trial, they have a right to appeal that bench trial de novo to a jury trial afterwards. So what we recommended is really just catching up to those 40 plus states to guarantee a jury trial anytime a person's facing a period of incarceration. Because again, people could get sent away for 3, 4, 5, just shy of 6 months. That's obviously hugely disruptive to their day-to-day lives. And it's our view that people, before they can sit away from prison for that long, deserve to have a trial before their peers. I should note, though, that to accommodate the possibility of genuine just administrative challenges here, the council delayed how long the changes for jury trial rights would phase in. So the bill itself, even though it had been passed in 22, was not scheduled to go into effect until 25. And even at that point, there would have been no changes to jury trial rights, and the changes would have slowly phased in year by year. We wouldn't have gotten to full universal jury trial rights until 2030. So that was trying to appreciate and recognize the possibility for real administrative challenges.
Right. And the ongoing issue of getting judges nominated and confirmed in a timely way. Well, great. Well, I'll go back to the timeline here a little bit. In November 2022, just about a year ago, the bill was passed by the council with pretty overwhelming support from the council at that time. Mayor Bowser and the U.S. Attorney's Office and a few others expressed some concerns about provisions, and she ended up vetoing the bill. The council passed legislation over her veto in January 2023, and it was forwarded to the Congress for a required 60-day review period. And we should note that their committee under Charles Allen had held a number of hearings and roundtables, but it seemed that this issue didn't really come to the fore until a year ago when all of a sudden it was sent to Congress and members of Congress seemed to raise concerns. As we know, Congress can exercise authority over DC laws. They can supplant our laws as they did with the control board back in 1995. They basically took over DC government for a period. And then in February of 2023, this year, the disapproval resolution was introduced in both the House and Senate. It was passed with bipartisan support in both chambers, and President Biden signed the legislation in March 20th. In the Senate, there were 14 Democratic senators who did stand with the district's version of the code that we'd sent to the Hill. But it was passed. The disapproval was passed, and President Biden signed it. So where do we go from here? I know we've gone back to the drawing board. There's a new bill that Councilmember Pinto shepherded through this year. What were the changes that were made to sort of in the wake of that disapproval?
Yeah, just speaking about the disapproval process, it was, I mean, enormously disappointing and frustrating, obviously, for those of us who'd worked on this project, and I think others in DC government who, genuinely understood and believed in the value of what this revised code was going to bring to the city. But part of it, in terms of the commission's work going forward, there had always been some chunks of criminal offenses that, just due to time and resource constraints, had not been revised as part of the RCCA. So the plan had always been, like I mentioned, there had been this delay in terms of when the bill would have become applicable, not till 2025. So there were chunks of offenses relating to animal cruelty, public corruption, traffic offenses, which had not been revised in the RCCA. The idea had been that we would continue working on those between now and 2025, and they would have been added as effectively as amendments. But that work is still going to continue. I mean, we're still hopeful that a version of this RCCA can pass. I mean, a number of council members have voiced publicly that their continued support for the project. The mayor, even in vetoing the bill, said that she agrees with roughly 95% of it, that it's all common sense modernization, and she had issues with a small number of provisions in the bill. And so hopefully we can get to a point where, yeah, there are some changes made to that 5% of the bill, and the vast majority of it, though, can continue to go on. But yeah, in the interim, of course, the council is going to continue its work to pass criminal legislation. And Councilmember Pinto has moved forward a number of pieces of legislation this year and continue to do so. There were some provisions in the legislation that she's passed and has proposed that were either taken from or at least were heavily inspired by changes in the RCCA. So the RCCA, a number of times, found problems in law where certain kinds of conduct was either not criminalized, or at least in our estimation was not penalized as severely as it ought to have been. So, for example, we had created a new firing gun in public offense and treated it as a felony. And that offense was taken almost verbatim. We had to make some technical tweaks to it, but was included in some of Councilmember Pinto's legislation. Also, we made some changes to clarify when, for example, strangulation, that it actually categorically constitutes a felony offense. One of the issues is that the definition of felony assault under current law is not entirely clear. And it's led to some litigation in some cases where people have been strangled and their felony convictions have been reversed. We had recommended changing the felony assault offense so that it was very clear that that kind of use of force would categorically be treated as a felony. And Councilmember Pinto has similarly taken up legislation along those lines. It's not word for word what we had proposed, but the same basic principles are there. And that's fine to have these sort of piecemeal changes in the interim, but it doesn't really address the really core foundational problems in the code, though.
Right. So you think the structural reform still needs to take place, and in a comprehensive way, clearly.
Yeah, absolutely.
Did she? So you say she's been taking up piecemeal legislation. Do you think some of it's been reaction to some of these things? Like, unfortunately, the member of Congress was carjacked in DC on Monday, just as we taped this, which is very unfortunate. And those things make the headlines. And do you think that the council is sort of trying to tune out that noise and keep their nose to the grindstone to actually, address crime in DC?
Absolutely. No, I think all the members are very attuned to the crime rate in the district and are trying to do what they can to address it. As a legislature, I think, to be honest, have limited levers of what they can do. They're only one branch of government here. They obviously don't control the executive or the prosecutorial agency, which is completely federally controlled.
Right.
So, yeah, I think they're taking this seriously. Something like the RCCA is obviously a huge lift. And so for the time being, I think the council members are trying to consider maybe more modest pieces of legislation that they can move through much quicker that could hopefully have some effect. But again, it's a serious problem that is, frankly, I think, difficult to tackle with any single piece of legislation. But I think they're certainly doing their work and are making some improvements here in smaller pieces of legislation to pass this year.
How do you think overall the communication was with the partners? You had the U.S. Attorney Office, a new U.S. Attorney being appointed, Matthew Graves, and of course working with the Attorney General and the executive. Did you feel that there was communication over the last few years, or was that a challenge in itself that you could comment on?
Yes, and as you noted, I believe in the intro, as part of our mandating statute, we had to work with an advisory group. And in fact, before we could even submit our recommendations to the council for their consideration, our recommendations had to be approved by that advisory group. And that advisory group is included as one of the representatives, not just a representative from the mayor's office, but a representative from the U.S. Attorney's Office and the Office of the Attorney General. So both prosecutorial agencies were involved in the process. I mean, this is going back years. So it's not only that they sort of came in at the last minute to review our whole package of recommendations and vote up or down. We went through multiple drafts of every single provision that was ultimately included in the RCCA. The first draft got reviewed by all the stakeholders. We then made changes. The second draft got reviewed. We made further changes. So the U.S. Attorney's Office has been involved for many, many years. And when it came time to vote on that final package, which had gone through multiple iterations, all the parties involved voted to send it on for the council's consideration. Obviously, everyone had their quibbles and critiques of the final product. No one, we're not going to get unanimity on a piece of legislation that large. But the U.S. Attorney's Office voiced their support. And I believe even U.S. Attorney Graves, again, despite some serious critiques that he had, also publicly said that, look, again, sort of the vast majority of this really is a common sense modernization and that his office supports it. I do know as the bill was first being considered by the council, there were conversations between council members, constituents, advocacy groups, and including stakeholders such as the U.S. Attorney's Office and MPD. And there were a number of changes made that we, to some degree, assisted with, working with council members to make sure that these changes to language were sensible and were accurate, didn't create other problems with how they would interact with other provisions in the code. So it was a really collaborative effort, and hopefully it will continue to be so going forward.
Great, wonderful. So you're still in existence. You're still working with the council
Yes.
to work on revisions. Okay, wonderful. And in your opinion, the DC affairs community and others communities, of course, are very concerned with DC's lack of statehood and equal standing with other American citizens, frankly, in our processes and our rights. Do you have an opinion about how our lack of statehood has affected the process overall?
Yeah, absolutely. So, speaking in my just individual capacity, I'm in support of democratic self-governance. I think the district and the residents of the district should have the basic liberty to make laws for ourselves, as you said, all the other citizens of the United States do. But even setting aside just principles of democratic governance, the pragmatic challenges with home rule became really apparent to me as working on this as the RCCA made its way through the Hill. So when Congress took up these disapproval resolutions, the CCRC, we didn't have a formal role in that process, of course, but we did a lot of media outreach. I also ended up trying to send information and have briefings for various members on the Hill, or at the very least their staffers, to inform them of, hey, this is what the bill is really all about. This is why it's important. This is the good it does. This is the way it's actually similar to the criminal codes in many of those members' home states. What became pretty clear, though, is this is an incredibly complex, large piece of legislation. And the members who are voting on this, I doubt any of them actually read it. I doubt many of them even read a very good summary of it. And in a certain sense, I don't blame them. I mean, these are members of Congress. They have matters of national or even international import to work on. And it just illustrated to me that as a strictly pragmatic matter, they're not really well equipped to make policy decisions for the district. They're not really well informed on day-to-day issues and problems that district residents face. And they, frankly, I don't think have the time and resources to really dig deeply to really understand fully what it is that they're actually voting on. I mean, there were some members whose staff really reached out and they really wanted to get into the weeds and understand things. And I could tell that they really read a lot of the summary and briefing materials that we had produced. I think they were the outliers, though. And I think for virtually any other kind of issue that may arise under home rule where Congress would want to intervene, I don't have confidence that those members or even their staffs are really going to have a clear sense of the policy issues at stake, much less what the needs and interests are of district voters. It just showed that even if in principle someone were to think that it's fine for Congress to exercise this authority over the district, as a practical matter, they're not going to really do so in a really highly informed way. And that was, again, setting democratic principles aside, it was extremely frustrating to hear members make pronouncements on this bill when it was pretty clear that they had hardly an idea of what they were voting on in the first place.
Right. And you stated that so well. I think it shows the super legislature role of the Congress in which unfortunately is structurally present under Article 1 of the Constitution, that we're a federal district We're not a state. We're trying to move towards that in various ways, and I don't attribute that view to you at all, but it is something that maybe needs to be corrected because you've got, 600,000 district residents who are laboring under this burden of oversight from Congress, so who come from many other areas and maybe have many different agendas. Mm-hmm. So that's something we're all working on. But we appreciate your service in this area and your service to the district in trying to get this reform passed. And we hope to keep in touch with what's happening at the commission and also keep an eye on Councilmember Pinto's committee to see what happens moving forward. Anything else you'd like to add about your role moving forward? Will you still be at the commission for the foreseeable future?
Yeah, that's the plan. And again, like I said, we're still really hopeful that this revised code can move forward. Again, of course, subject to some changes. Unfortunately, a lot of this is going to depend on national level politics that are outside of our hands. But I think the people in our own district government who represent us here, I think do really recognize the need for this comprehensive revision. And so I sincerely are hope that we're going to move forward with this bill. In addition, it's just the work the CCRC is going to do. Our mandate was also very broad, just to provide any kind of recommendations related to criminal law in the district. And so, we're going to continue to submit recommendations. And we've been heavily involved in testifying before the council on a variety of bills related to criminal law. And so we'll continue to do that work. And so we'll be here in the trenches, quietly toiling away. And we really hope the next, whether it's the next year, next 2 years, 3 years, whatever it is, that some version, RCCA version 2 will make its way back up to the council. And that time, we sincerely hope that the federal government will not inappropriately meddle.
Wonderful. Okay, well, thank you very much, Jinwoo Park. We greatly appreciate your time on the podcast. Thanks for being with us.
Thanks for having me today.